welcome to the deep dive. Today we're tackling something really practical, understanding the act on the regulation of terms and conditions in South Korea. Think of it as like your personal cheat sheet for navigating contracts with businesses.
Yeah.
Giving you the power to maybe spot unfair clauses before they, become a problem.
And for this deep dive, we've got a great resource excerpts from a lecture document by the Korea Fair Trade Commission, the KFTC.
Oh, nice.
So it gives us a real insider's look at how South Korea approaches consumer protection.
Exactly. So our mission today is to pull out the core principles and the real-world implications of this act. Make it clear, understandable, and relevant for you.
Right.
We'll even get into the story of how this law developed and what it actually means for your sort of day-to-day dealings with companies.
Right.
So where did this all kick off?
Well, it's fascinating, really. South Korea went through this incredibly rapid transformation starting back in the 1960s. Huge industrialization, mass consumption taking off.
Yeah.
And this led to a whole wave of new ways of buying and selling. Things like installment payments, door-to-door sales, even factoring. Plus more service contracts, too. Travel, accommodation, that kind of thing.
And I guess with all that new activity, contracts maybe got a bit messy. Unfair terms started showing up.
That's exactly it. Despite the basic idea that you should be free to agree to a contract, freedom of contract, these unfair terms just became really widespread. And it wasn't just annoying. It actually started to hinder fair trade and really harm consumers, put them at a disadvantage.
So people started realizing, hey, we need some rules here to make things fairer.
Yeah, looking at the bigger picture, from about 1980 onwards, you had legal experts, consumer groups.
Right.
They really started pushing for legislation. They saw the limits of the existing laws.
And that leads us to this act. What's the official line? Why was it created?
So the Act on the Regulation of Terms and Conditions, that's the official title. It was basically created to stop businesses from, abusing their stronger position by writing and using unfair contract terms.
Right.
The ultimate goal. Establish a sound trading order, protect consumers, and, help promote a more balanced improvement in public life overall.
Right, a level playing field. So the act regulates terms and conditions. What does that actually mean, legally speaking?
The Act defines it pretty broadly. It's basically any contract content, doesn't matter what it's called or how long it is, that a business prepares in advance.
So pre-written stuff.
Exactly. In a specific format designed to be used for contracts with lots of different customers. The idea is standardization, formalization, makes things efficient.
Which makes sense for businesses. But as the KFTC notes, because the business usually writes them, there's a risk things could be a bit one-sided. Yeah.
That's the inherent risk, isn't it? The power imbalance. The business is often in a stronger position than the individual customer. So they can write terms that might be unfair, maybe limiting their own liability, dictating performance, controlling termination. And that's where the Act comes in, to regulate that content, check for unfairness. And the KFTC is the body overseeing it all.
Okay, so how does the Act actually do that? What are the main regulatory tools it uses?
It basically uses three main types of regulation, or controls: incorporation control, interpretation control, and unfairness control. Think of it like a three-step check.
Okay, 3 steps. Let's start with incorporation control. What's the first check?
The first question is simply, are these terms and conditions actually legally part of the contract between the business and the customer? Were they properly incorporated?
And what does the business need to do to make sure they are part of the deal?
Well, the Act says they have to clearly present the terms, specify them, and provide them to the customer.
Right.
They can't just bury them somewhere. It needs to be upfront.
Basic transparency makes sense. Now, what if you and the business agree on something specific, separately, that's different from the standard terms?
Good question. That's where the principle of individual contract precedence applies.
Okay.
If there's a clear, separate agreement on a point and it conflicts with the standard terms, that specific individual agreement wins out. It takes priority.
Really?
Yeah, the Supreme Court actually confirmed this in a case back in 1998. They basically said contracts are binding because the parties agreed to the content. The specific agreement matters most.
So a direct deal overrides the fine print. Got it. What's step 2? Interpretation control.
Interpretation control is all about figuring out what the words in the contract actually mean.
Okay.
It uses certain principles to determine the rights and duties of both sides.
And what are these key interpretation principles?
Well, there are a few big ones. First, the principle of objective interpretation,
Right.
meaning terms should be understood the way A general average person involved in that type of transaction would understand them.
Right. Not some secret meaning only the business knows.
Exactly. It considers the collective understanding, not just one party's specific interest.
Okay, that sounds fair. What else?
Then there's the principle of author disadvantage, or sometimes called contra preferentum.
Fancy name.
Yeah. It just means if a term is unclear, ambiguous, could mean a couple things.
Yeah.
It should be interpreted in the way that favors the customer.
Because the business usually wrote it.
Precisely. If you write something confusing, the confusion works against you.
I like that. Is there another one?
Yes, the principle of good faith. This is fundamental. It means businesses have to consider the legitimate interests of their customers when they create and use these terms.
So act fairly.
Basically, yeah. Maintain fairness, consider the other side.
Can you give us an example of this interpretation stuff in action?
Sure. The KFTC had a case. It was a supply contract from a company A, and one clause literally said that their interpretation of the contract would be the final word if there was a dispute.
Wow, really?
Yeah. And the KFTC said, nope, that's unfair. It violates objective interpretation. It doesn't disadvantage the author of unclear terms. And it certainly doesn't show good faith. You can't just declare your own interpretation as law.
That seems like a blatant attempt to rig the game. Okay, so step 1, are the terms in the contract? Step 2, what do they mean? Now step 3, unfairness control. What's the focus here?
Unfairness control kicks in after we know a term is part of the contract and we know what it means. The question now is simply, is this term actually unfair?
And how do they decide what's unfair? What's the standard?
The main guide is that principle of good faith again. Plus, the Act itself, in Articles 6 through 14, gives specific examples of clauses that are generally considered unfair.
So a general rule and then a list of specific things to watch out for. How do those work together?
It's kind of like a two-stage filter. The KFTC first checks if the clause fits into any of the specific no-no categories listed in Articles 7 to 14.
Okay.
Things like limiting liability, unfair cancellation rights, stuff like that. If it doesn't clearly fall into one of those specific buckets, then they apply the broader general principles of fairness from Article 6.
Gotcha. Specifics first, then the general rule if needed. Let's dive into those specifics then from Chapter 2. Article 6, the general principles. Seems like the place to start.
Absolutely. Article 6 is foundational. It says any term that's not fair and goes against the principle of trust and good faith is void. Simple as that.
Okay.
But importantly, it also gives us some clues, some presumptions about what's likely to be unfair.
Oh, like what kind of clues? What raises a red flag?
Article 6, paragraph 2 points out a few things. First, if a clause is unreasonably unfavorable to customers, that's a big one.
Right.
Second, if it's something customers would have real difficulty anticipating, just given the type of transaction it is, sort of springs it on them.
A surprise disadvantage.
Exactly. And third, if a clause restricts the customer's essential rights under the contract so much that it basically undermines the whole point of the agreement.
Like it guts the contract's purpose.
Precisely.
Can you give a real-world example of something unfair under these general principles?
Yeah, there was that KFTC case with Bumyang Foods agency agreement. They had a clause allowing Bumyang to just unilaterally change the sales territory assigned to their agent.
Oof, that could be huge for an agent.
Right. The KFTC found that unfair under Article 6.2. Because changing the territory is such a core part of the deal, it really needs mutual agreement, especially since the agent is running their own business based on that territory. You can't just yank the rug out.
Definitely sounds like it disadvantages the agent unfairly. Okay, moving on. Article 7. Prohibition of exemption clauses. What's this about? Avoiding responsibility.
Pretty much. Article 7 targets clauses where businesses try to get out of being legally responsible for things.
Like what?
Specifically, it voids clauses that excuse a business from liability for harm caused by their own or their employees, intentional wrongdoing, or gross negligence.
So you can't escape responsibility for major screw-ups.
Exactly. It also bans clauses that unreasonably limit how much compensation they have to pay, or clauses that shift risks onto the customer that the business should legally bear, unless there's a really good reason.
Okay.
And it covers warranties too, clauses that unfairly exclude warranty liability or make it super hard to claim, or limit warranties on samples without justification. The basic idea is businesses can't use the fine print to just dodge responsibility for serious failures.
So the general rule is you're accountable unless there's a substantial reason otherwise.
That's the gist, and substantial reason isn't taken lightly. The KFTC looks at everything: the clause's purpose, industry norms, laws, the product, the business's needs, and crucially, the potential harm to the customer.
Can you give some concrete examples of exemption clauses that would likely be void here?
Sure. Think of a parking garage sign saying, "Not responsible for any damage or theft ever." That likely violates Article 7.1.
Right.
Or a real estate contract making the buyer liable for, say, earthquake damage after they sign but before they even get the keys. That could fall under 7.2. And for warranties, maybe a commercial property contract saying the buyer can't complain if the actual square footage is different from the brochure. That might hit 7.3 or 4.
Those all sound like ways to leave the customer holding the bag. Any KFTC examples on this?
Yeah, back to that Bumyang food case. They had a no returns for normally shipped products clause.
Okay.
The KFTC worried this could unfairly limit Bumyang's responsibility if those normally shipped products actually had hidden defects causing losses for the agent. So they flagged it as potentially violating Article 7.3.
Right. It could cover up quality issues. Okay. Article 8. Predetermination of amount of indemnification. Sounds like setting penalties in advance.
Exactly. It deals with clauses that specify how much someone pays if they break the contract, liquidated damages, penalties, late fees, that sort of thing.
Why have those?
Well, the idea is partly efficiency, avoid fighting over exact damages later, and partly to encourage people to stick to the deal. But Article 8 says any clause imposing unreasonably heavy penalties on customers is void. You can agree on damages, but they can't be excessive or purely punitive.
So penalties have to be reasonable. How do they judge unreasonably excessive?
Courts and the KFTC look at a bunch of things: the parties' financial situations, the contract's purpose, how the amount was decided, the penalty versus the total contract value, the likely actual damages from a breach, industry practices.
Okay, context matters. Example of something potentially excessive.
Maybe a lease agreement saying if you terminate early, you forfeit, say, 30% of your entire deposit as a penalty. Depending on the deposit size and circumstances, that could easily be seen as way too high.
Yeah, that sounds pretty harsh. Okay, Article 9. Cancellation or termination of contract. This seems super relevant for consumers.
It really is. Article 9 goes after clauses that unfairly restrict your legal right to cancel or end a contract.
Okay.
It also stops clauses that unfairly give the business extra cancellation rights or make it too easy for them to cancel. And it prohibits excessive charges if you cancel, or clauses that unfairly reduce what the business owes you if they cancel.
So it covers both sides ending the deal.
Yeah, and one more thing for ongoing contracts: it voids clauses that set unreasonably short or long terms or have automatic renewals that stack the deck against the customer. It's all about fair exit routes.
Making sure getting out of a contract isn't unfairly tilted. Examples.
Sure. A clause saying you can't cancel your gym membership even if they close the pool you joined for. Void.
Yeah.
Or a clause automatically canceling your phone plan if you're one day late on one bill. Probably unfair. Or those joining fees are non-refundable no matter what clause is. Also likely problematic under Article 9.
Those definitely sound like traps. Okay, next up, Article 10. Performance of obligations.
This one's about how the contract duties get done. It voids clauses that let the business, without a substantial reason, just unilaterally decide or change what they have to do.
So they can't just change the service they promised.
Not without a good reason, no. It also stops them from just suspending their performance or handing off their duties to someone else without justification. The key is, you can't just rewrite the core deal by yourself.
So no changing the rules mid-game without a solid justification.
Yeah.
Examples.
Like a supplier contract saying they can stop deliveries or slash your credit limit whenever their circumstances change, regardless of your situation. That's likely out.
Okay.
Or maybe a surety agreement where the guarantor is deemed to agree to major loan changes automatically without ever being asked. Also problematic.
And what counts as a substantial reason for them to make a change? What does the KFTC look at?
They consider a lot: the original contract intent, industrial practices, relevant laws, the nature of the service, whether you could negotiate initially, how easily they can make the change, their actual business need,
Right.
and crucially, how much it screws over the customer. They had a case involving an airport shop contract. The airport corporation could just unilaterally change terms related to airport operations. KFTC said, no, that's too much power under Article 10. No sufficient justification given. You need that substantial reason.
Really highlights that requirement.
Yeah.
Okay. Article 11. Protecting rights and interests of customers. Sounds broad.
It is a bit broader. It safeguards fundamental customer rights. It voids clauses that unfairly take away your legal defenses or your right to offset damages you might owe.
Okay.
It also stops clauses that, without reason, prevent you from fulfilling your own obligations for a time like making a payment.
Interesting.
Plus, it tackles clauses unreasonably stopping you from contracting with other businesses and clauses letting the business spill your confidential info without justification. It's about keeping your basic legal toolkit intact and not being unfairly boxed in.
So preserving core rights and freedoms.
Yeah.
Examples here.
A lease saying the landlord can take forever to return your deposit after you move out could violate this.
Okay.
A bank agreement where any minor breach means you instantly lose your agreed repayment schedule? Problematic.
Right.
Those super broad non-compete clauses, making it impossible to work elsewhere, could fall foul of this. Or forcing you to agree to marketing use of your credit info just to join a loyalty program may be unfair.
Those all feel like potential overreaches. Okay, Article 12. Deemed expression of intent. This sounds tricky.
Yeah, it deals with clauses where your action, or even inaction, is automatically taken to mean you agree to something, even if you never said so.
Like silence means consent.
Kinda. The article says these clauses are generally void unless the business clearly tells you beforehand what will happen, gives you a reasonable time to object, and you don't. Or if giving notice is impossible.
So there needs to be clear notice and a chance to say no.
Exactly. It also voids clauses with unreasonable rules on how you express your intent, or clauses that just assume the business's notice was received, or give the business way too long to make up their mind about something affecting you. Key idea. You can't just assume agreement from silence unless it's handled very clearly and fairly.
Right. So no tricking people into agreeing.
Big examples. Maybe a utility contract saying a new tenant automatically owes the old tenant's debt if they don't apply for a name change. Problematic.
Yeah.
Or super stretched short deadlines for changing a hospital appointment that are almost impossible to meet. Or a clause saying just sending a notice counts as communication even if you never get it.
Those could definitely lead to unfair outcomes. Article 13. Additional obligations of agents. This is specific.
Yeah. Protects agents acting for customers. It says if the customer breaches a contract the agent arranged, any clause making the agent responsible for the customer's failure is void.
So the agent isn't automatically liable if their client messes up.
Exactly. The agent acting in good faith shouldn't be on the hook for the client's performance failures.
Makes sense. Examples.
A clause making an agent pay damages if a contract they set up gets canceled, even if it wasn't the agent's fault. Or just a blanket statement. Agent is responsible if customer fails to perform. The KFTC had a case with a livestock bidding guide. It made the local agent responsible if the foreign exporter, the customer, didn't meet quality standards. KFTC said unfair under Article 13.
Yeah, the agent facilitates.
Yeah.
They don't guarantee the client's actions. Okay, last specific one. Article 14. Prohibition, etc. of filing lawsuits. About legal rights, clearly.
Yep. Voids clauses that unfairly stop customers from suing the business.
Okay.
Or clauses forcing you to agree to have disputes heard only in a specific court that's really inconvenient or unfair for you, like the business's home turf miles away.
Right, jurisdiction clauses.
Exactly. It also bans clauses that unreasonably dump the entire burden of proof onto the customer in a lawsuit. Core idea. Fair access to the legal system.
So businesses can't just immunize themselves or make suing them impossible.
Pretty much. Clauses saying no liability, civil or criminal, no matter what, void. Forcing you to sue in the court near their HQ, even if the deal happened elsewhere. Problematic. Making you sue in a foreign country for their Korean operations. Also suspect. And clauses trying to stop you making legitimate claims or shifting the burden of proof unfairly. All targets under Article 14.
That definitely seems crucial for a fair process. You also mentioned Articles 15 and 16 briefly.
Right. Article 15 just clarifies that the specific bans in 7 to 14 might not fully apply in some niche areas, like maybe standard international trade terms or other special cases set by decree.
Okay, some exceptions.
And Article 16 deals with partial invalidity. If some terms are void, the rest of the contract usually still stands.
Usually.
Unless the void parts are so essential that the contract can't work without them, or if what's left is super unfair to one side, then the whole contract might be void.
Okay, helpful clarification. So that covers the types of unfair clauses. Now, how is this act actually enforced? Chapter 3, right?
Right. Chapter 3, Regulation of Terms and Conditions. Article 17 is straightforward. Businesses are banned from using any of those unfair clauses from Articles 6 to 14 in their contracts.
Simple prohibition. And if they do it anyway, what can the KFTC do?
Article 17-2 covers corrective measures. The KFTC can first recommend the business fix it, delete, or change the unfair term.
A recommendation.
The suggestion.
Yeah, non-binding initially. But they can issue a legally binding corrective order in certain situations.
When does it get serious like that?
If the business is dominant in the market, abusing bargaining power, if customers have little choice or ability to negotiate, if the terms are compulsory, if the contract's hard to cancel,
Okay.
and crucially, if ignoring a recommendation is causing widespread harm to consumers, then the KFTC can issue an order, which might include making the business publicly announce the correction.
So orders have teeth. Recommendations are the first step.
Exactly. And Article 18 deals with terms approved by other government agencies or bank terms. If the KFTC finds unfair stuff there, they notify that other agency or the Financial Supervisory Service for banks and ask them to fix it.
So they coordinate with other regulators. Right. And if they send a request to another agency, they won't then issue a direct recommendation or order to the business itself. Avoids duplication.
Makes sense. So we have recommendations, orders, requests for correction, any other enforcement tools.
Yep. Beyond those, there are administrative fines. Can go up to 50 million won, depending on the violation.
Okay.
Specific fines for misusing standard term seals or blocking investigations. Smaller ones for not explaining terms properly or mismatching displays. And then there are criminal sanctions.
Criminal.
Yeah, ignoring a corrective order can lead to up to 2 years in prison or 100 million won fine. Both the company and individuals can be penalized unless they prove they took proper care to prevent it.
Wow. Okay. So, serious consequences for noncompliance. Now, the Act also mentions standard terms and conditions. What are those?
Standard terms are basically pre-approved contract templates. Businesses or industry groups develop them, and the KFTC reviews and approves them.
Why? What's the point?
The goal is to promote fair trade proactively and prevent unfair terms from getting out there in the first place, especially in common transaction types.
So what's the benefit of using these KFTC-approved terms?
For businesses, it saves time and effort drafting contracts. Plus, it reduces the risk of disputes over unfair terms later. Big plus.
Right.
For consumers, it offers peace of mind. You know these terms have been vetted by the KFTC for fairness, makes it easier to understand your rights and feel secure. The KFTC even has a marking system so you can spot contracts using these standard terms.
A seal of approval, kind of.
Sort of, yeah. It builds trust and efficiency.
Sounds like a really positive initiative. Lastly, the Act mentions a dispute resolution system. How does that work?
Right. To help sort out disagreements without necessarily going straight to court, the KFTC sets up a mediation committee.
Okay.
If a customer feels harmed by unfair terms, they can apply for mediation, or the KFTC can initiate it. The committee then tries to help the parties reach an agreement. It's an alternative path covered in Articles 24 to 29.
So a less formal way to resolve things.
Exactly. Tries to find common ground.
Well, this has been incredibly thorough, a real deep dive into this Act. To wrap it all up, what's the main thing you want listeners to take away?
I think the key takeaway is just how vital this act is for protecting you, the consumer, from unfair contract terms. It sets out fundamental rights, puts obligations on businesses. It's all about creating a fairer playing field.
Yeah, and knowing these principles really does empower you, doesn't it? Gives you more confidence when you're faced with a contract, helps you maybe spot things that don't seem right, encourages you to be more aware.
Absolutely. It's about not just blindly clicking, I agree.
Right. So maybe a final thought for everyone listening.
Yeah.
As you go about your day, think about the contracts you encounter. Your phone plan, online purchases, gym memberships. How might the principles we talk about apply? It might just change how you look at that fine print next time. Thanks for joining us on this deep dive.